call file number 2025-0203, Sarah May Kite versus Eric Robert Thornburg. I'll note the appearance of Ms. Kite on her own behalf as the appellant, as well as Tatiana Hackman representing the Appellee. Sitting today are Justice Daniel Crothers, Justice Lisa Fair McEvers, Justice Jared Tufte, Justice Douglas Barr, and Justice John Jensen. Ms. Kite, whenever you're ready, you can release your mute and begin your argument.
May it please the court, Chief Justice Jensen, Justices of the Supreme Court. My name is Sarah May Kite Beeland. I'm here on behalf of myself, and I'm an attorney located in Grand Forks, North Dakota. Just a little bit of history about this case is Mr. Thornburg and I separated in 2013. Eventually, the divorce went through in 2016. The reason we separated was there was extreme physical, financial, sexual, and psychological abuse perpetrated against me by Mr. Thornburg, to the point that I almost died. Social services became involved back then. I believe it was in 2013. They brought a CHIPS proceeding against Mr. Thornburg for his failure to respond, his failure to cooperate, and to complete the services they required of him. Throughout those proceedings, that it was found that Mr. Thornburg actually admitted to the abuse and that there were alcohol problems on his behalf. Some of the allegations back then was that he strangled me, he suffocated me to the point where I had broken blood vessels in my face. There were times that I passed out, not knowing if I would ever wake up again. After that, the children were in my primary care. Mr. Thornburg had every other weekend, and 6 weeks in the summer is what we had agreed to. He was not consistent with his parenting time. He would often show up several hours late, maybe a day later. Sometimes he would forget completely, and things of that nature. So the children have gotten older. We have 4 joint children together. Our oldest one just turned 18. She had been refusing to go to parenting time on and off since between her 8th and 9th grade year. After that, there were multiple other instances where the rest of the children were refusing to go. In 2023 and 2024 school year, at the beginning of that school year, Mr. Thornburg started calling the police on a regular basis for welfare checks and things of that nature when the children weren't going. Things went on from there. I requested a domestic violence protection order. At the first hearing, there were many findings made by Judge Whalen, and I did not want to put the children in the middle, did not want them to have to testify. So ultimately, Judge Whalen had a legal question in front of her that was, well, if the children aren't here testifying that they're afraid, is mother's fear, mother's reasonable fear, was her words, enough to grant a protection order for these children? And ultimately, she decided no. So then after that hearing, the children started going back to parenting time with Mr. Thornburg. He allowed them to have boyfriends spend the night in an effort to entice them, I suppose. And there were some things that came up. Another mother of one of the boyfriends had disclosed her concerns of inappropriate sexual conduct, grooming-like behaviors. So our second oldest daughter also then disclosed that to me, and then she went immediately and reported it to police. There was a social services investigation and another domestic violence protection order hearing. At that hearing, Judge Olson decided that there were 2 allegations, one being drunk driving with the children and the other being the sexually inappropriate grooming behaviors and comments, that those were not enough for an imminent physical concern to award a domestic violence protection order. So after that, Mr. Thornburg brought a contempt motion or application with the district court in the family law proceedings, and 2 of the children testified, and social services testified to all of these concerns and that the children were not going. Mr. Thornburg himself even testifies the children aren't going. And he's the one who goes to pick them up while I'm at work, and they're just not going with him. And ultimately, the district court enters a contempt order. And I guess the reason we're here today is it appears that Mr. Thornburg makes claims in one case and then changes them in front of the district court, changes his story, and his claim and even his own testimony is that I just don't encourage them enough, which by all means, he couldn't know because he's not there to experience it firsthand knowledge, that kind of thing. And yet the district court simply agrees that because these children aren't going, that it must be my fault. But the legal analysis required is, did he provide enough evidence? The burden is on him. If he were to have provided enough evidence, then we go into an analysis on whether or not there's good cause reason to be interfering. However, there's just simply no evidence that there was any interference on mine. I mean, it's important that we have court orders and judgments that are clear. It's clear what everyone's responsibility is. And if he's responsible for picking them up and I'm not there at work, whatever, how then could one be interfering? I think it's important, not only in the context of this case, but other cases, as in all family law cases, children get older, children become teenagers, children refuse to go with one parent or the other for multiple reasons. We just went over several of the reasons, but there were sports games that they were upset that they were going to miss. There's other activities. There's actively running away from some of the children, locking themselves in public facility bathrooms. There's running down dark alleyways, and he can't get them to go with him, and he's calling me to help him. He even testified that there were times that I helped him. There were times that they called me to pick them up. There were times that they wanted things that he didn't have, and I brought them. But when you look at all kinds of family law cases, do we really want courts holding people in contempt for children refusing to go? Whose burden is it to make children go? And I want to point out that at the time of these allegations, where these children are actively refusing to go every single time, where they just started not going at all, I was pregnant. I have multiple children. How am I supposed to put 4 children, 3 of them being teenagers, over my shoulder when I'm not even there? But even hypothetically, if I was there, how does the district court decide whose responsibility is to force compliance? So my point is that in the grand scheme of all family law cases, the judgment needs to be clear on what it is you can and cannot do. And if we're going to hold people in contempt, which parent will that come down on? Which parent has to make these children go? I also want to point out some stuff that was in the briefs and in the testimony. So I talked a little bit about Mr. Thornburg's testimony was that I helped him, was that he knew that he was able to pick up some of the children from school, that I had never done anything with the school to try to oust him from picking children up there. He admitted in his testimony to driving drunk with the children, to saying incest is the best when you put your sister to the test, noting that we have 3 girls and then the 4th child is a boy.
Ms. Kite, I have a question, and I just want to let you know that I was listening the whole time. I was having trouble with my video, but on that comment, and I'm not going to repeat it, on the comment that you made about incest, was that made in front of the children, or was that made randomly somewhere else?
To the children, encouraging the children in
That's your
specific
position, but that is denied by your ex-husband, correct?
I don't think it was denied at the district court level. When I asked him if he said that, he acknowledged that he did. I do understand that in his brief, he's now attempting to say that he didn't admit that. However, he says he possibly made that comment to our son, and that is a phrase that is out there. If I would have thought that he wasn't admitting to it, I would have kept questioning on it. It's hard to read things in transcripts, and you guys are certainly free to listen to the recordings, but it was very clear that he was admitting that he made that comment to our son. In addition to that, there was a lot of comments about playing in sexy sports, doing things to make your appearance look better to the girls, and even clarified that the reason he said that was so that they would have sexier bodies. The social worker, Michelle Manley, the social services supervisor, testified that forensic interviews were completed on the three girls, that they all had these interviews, that they all made credible comments about the sexual grooming comments and behavior that was occurring there, and that it was inappropriate that social services had attempted to safety plan with Mr. Thornburg. And then they sent him a letter. They did not send me the same letter. There was correspondence with me about safety planning and how we go forward. And none of that ended up coming to fruition with Mr. Thornburg. In that time period, I was actively trying to get the children to go to supervised visitation. There's 4 children. They all have different responses. One of them went every time. The youngest one went every time. The oldest one went some of the time. And the other 2 didn't go. I think the third went maybe one time. So they're all a little bit different in their responses, but I was trying to get them to go to different places. And the district court makes findings that I've changed the bar on him, when really, again, it goes back to, if he could have picked them up, he would have. It's the children that were refusing to go. The only way that he had some form of communication or parenting time with them was because I had convinced them to go to supervised visits. Whether that worked on all of them is a different question, but it's not changing the bar to say, let's try and get something going here, because you trying to pick them up is not working. I will also note that the emails where the district court's referring to when it says the changing of the bar on his parenting time, there was a time period that we had discussed where he would go through supervised visits and see if that would work. So the 2 children that went somewhat regularly to supervised visits attempted to go to his house for an unsupervised visit for a weekend or Father's Day or something that year. And the oldest one has her own driver's license, so she drove. He then convinces her to get into his vehicle, says he's going to meet her halfway between Grand Forks and Walhalla. And then he abandons her car there. So after that, she refused to go without having access to a car. So again, I say, okay, let's bring him to kids first. That's not me interfering. That's me attempting to get him some sort of parenting time. And again, it goes back to, if he could get them to drive there with their own car and driver's license, if he could get them picked up from school or wherever, then he would have. And it's the same for me. What can I do when I'm not there? What can I do even if I was there? Do you expect parents to physically wrangle up other children, no matter what their medical status is at the moment, whether they're pregnant, have some other form of disability, or they're completely physically able to pick up children? But I don't know any person who's able to pick up 4 children at one time, shove them in a car, and hope that you can keep them there long enough for that car to start driving. I think that contempt is supposed to be, you did this, you locked the door. If you have toddlers and you just say you're not picking them up, and you lock your door at your house, you can't come get them, or you rush to the school or daycare and you say, I'm picking them up, so the other parent can't. That's active and willful interference. But when you have children who for years have gone out the door by themselves and at different stages stop going sometimes, stop going all the time, whatever the case may be, that's not the same. That's not active interference. You know, what is it in the judgment that requires me to take off work, to leave what I'm doing, to go home, to physically put 4 children over my shoulder and hand them over and hope that that works, when sometimes, like the issue where the one child locked herself in a bathroom at the high school, that was after he already picked them up for parenting time. What am I responsible for making them stay with him during his parenting time too? I mean, I can't be there to supervise his parenting time. And that's what's really, you know, the flipping the burden on this case. Like, what was it that was done that violated a clear and unambiguous portion of the judgment Because if we don't have that, then how do we fix it going forward? We're just going to keep coming back and we're going to keep coming back. And anytime a child doesn't go, then one parent can file a motion for contempt and basically get the other parent sanctioned simply because the children don't go. And here, the district court, my first argument is that she misapplied the law, and the second argument is that it was an abuse of discretion because there were no, it was just an irrational conclusion. We have myself, we have social services, and two of the children testifying that they don't want to go, that they're refusing to go, that they're running away. And she disregards all of that. But in addition to that, we have Mr. Thornburg testifying, yes, they call mom and want to go home. Mom's never come and picked them up. She brings them stuff. She's never done anything to block me from getting them at school. His only gripe in his testimony is that I don't encourage them enough. And so if we have that as the standard, it's really an irrational conclusion, because you're saying that one parent or the other, and we don't know which one depending on other cases in the context, is responsible for mind control, like to control what children say, what they do.
Counsel, does a parent in that situation have an obligation to take away privileges, take away a phone, take away a car, take away other things in order to encourage a child to do something the child should be doing?
So I think it depends on the context, because like I said, the legal obligation, the legal standard in contempt is first the one parent has to prove this other parent actively interfered, and then it would come down to good cause. So if you're saying, if the parent's saying, yes, I actually interfered and I withheld these children because he's abusing them, for example, well then no, I don't think that there needs to be consequences. We didn't get there in this case. She never went through that analysis. But if you have children that just don't want to go because they want to go do something else that's more fun and they're just refusing to go, then absolutely, yeah, you would have to say, well, then you're not going to do that fun thing because this is the other person's parenting time, right? Or whatever other consequences. So it would be very case dependent. And in this case, we never got there. So I mean, I could go into what's actually happened, but I don't need to, because we never got there in the analysis at the district court level. The final thing I argued in my brief was that there was attorney's fees ordered, and there was simply no evidence to support ordering those attorney's fees. That was my argument in the motion for Rule 11 sanctions, in addition to some other stuff, like he was asking for a reduction in child support for having the children less, and I said, well, that's not supported by the law. And in addition to that, I was saying he has no evidence because none exists, because I'm not there, I haven't done anything. So I'm asking for the contempt order to be reversed, the attorney's fees to be reversed, and the compensatory parenting time to be reversed. When we're talking about the compensatory parenting time, I just wanted to point out that the district court entered compensatory parenting time for all 4 kids, even though she says that it's understandable why the oldest child, who was 17 at the time, didn't want to go. So if it's understandable that she doesn't want to go, then that's not contempt. And so I don't think you can enter compensatory parenting time or remedial sanction for a child that the court says doesn't want to go.
Wouldn't that be moot now because that child is over 18, or is there still parenting time that attaches to that child?
Right, there is still more compensatory parenting time to go. She is over 18. I would think that it would be moot, but it also, as far as like she's over 18, if the district court were to have said, but when she turns 18, this is no longer in effect. But the district court didn't say that. It says it awards compensatory parenting time even after her 18th birthday.
Is she still in high school? She's still attending high school? Okay, thank you.
Yes. And so with that, also would be the attorney's fees too. And is it a portion for one child, all children? And then in addition to that, she violated the stipulated judgment that said 7 days, no more than 7 days could the children be with Mr. Thornburg in entering that compensatory parenting time. Thank you. I will reserve my 10 minutes for rebuttal.
Thank you for your argument this afternoon, Counsel. Ms. Hackman, whenever you're ready, you can release your mute and begin your argument.
Thank you, Your Honor. May it please the court. My name is Tatiana Hackman, and I am appearing for the appellee and defendant Eric Robert Oman Thorberg, who I will refer to as Eric throughout this argument. I want to preface this by saying I apologize for the quality of my voice today. I have a little bit of a head cold. Eric appears in response to the plaintiff and appellant's Sarah Mae Beelan's appeal of the district court's order dated April 4th, 2025, in which the court held Sarah in contempt for violation of the party's judgment from 2016. Sarah raises 3 issues before the court: whether the district court misapplied the law, whether the district court abused its discretion, and whether the remedial sanctions for attorney's fees and compensatory parenting time should be reversed. The first and second issues largely overlap. If there is a misapplication of the law, there is an abuse of discretion. Additionally, Eric has requested attorney's fees for this appeal, which I will touch on at the end of my argument. I want to first discuss what this case is and what this appeal is not. It is not an appeal from a motion to modify primary residential responsibility or to amend Eric's parenting time. The only times that there were orders in place relating to Eric's parenting time were the 2 domestic violence protection order cases, both of which were dismissed, and the ex parte order that was brought after Eric had brought his application for order to show cause. So turning to what this appeal is, it is an appeal for the order on the application to order to show cause. The party's judgment dated September 19th, 2016 at paragraph 15 provides that Eric will have parenting time with the children every other Friday after school until Sunday evening, and during the summer he would be entitled to 6 weeks of parenting time. On October 4th, 2024, Eric filed an application for order to show cause, outlining that he had not had parenting time since January 2024, with a couple exceptions here and there with some of the kids for supervised parenting time. The district court issued an order to show cause, and a hearing was held on January 24th, 2025. On April 4th, 2025, the district court issued its order holding Sarah in contempt. Sarah's first argument on appeal is that the district court misapplied the law. Her argument is essentially that the burden was shifted from her to explain why she should not be held in contempt. This position is based on a fundamental misunderstanding of contempt law and what we're required to show at hearings. Eric brought his application for order to show cause under North Dakota Century Code section 2710-01.1 subsection 1C, which includes intentional disobedience, resistance, or obstruction of the authority, process, or order of the court. Our district courts have large discretion in determining whether a contempt has occurred. In this case, there has been no misapplication of the law. Eric set forth that he had sporadic parenting time with some of the children since January 2024, clearly not getting his parenting time under the party's judgment. There was a clear judgment. There was no question of what his parenting time was going to be. So Eric establishes that through his declaration, which was received into evidence. He testifies at the hearing. As is the case in all contempt proceedings, Sarah then had the opportunity to explain why she should not be held in contempt, which the court rejected.
Ms. Hackman, I've sat on these types of cases when I was on the district court bench when teenage children do not want to visit the other parent, whatever the situation. What is the custodial parent or the parent with primary residential responsibilities supposed to do when there is an obstinate child that refuses to see the other? What is it that, how do we solve this problem?
Your Honor, that's a question that practitioners and district courts are tasked with regularly and comes up with regularly in our practice. It's a real concern when there are resistant children involved in what we do about that. Practitioners struggle with it, judges struggle with it. Here's the point I will make on that. That is why following the proper procedure to consider a child's preference is of the utmost importance. If we look at a motion to modify primary residential responsibility or a motion to amend parenting time, we're looking at the statutory best interest factors, both of which explicitly contain the preference of a child, what's going on there, are there mature reasons for that preference, is a parent getting involved that's influencing the child. That's contained within the best interest factors. But ultimately, even then, while the child can testify as to their preference if they're mature enough, that is just one of many factors that the court is considering in making an ultimate determination on the issue. The case law in looking at those best interest factors is such that the child's preference is only one factor and it's not usually determinative. That could certainly be raised within a contempt proceeding as a defense. But then it's the district court's discretion as to what to make about that argument. If you're saying, I have a resistant child that doesn't want to go to parenting time. And that's why the standard of review is so important in these cases. It's because courts are tasked with making these decisions, considering the evidence, saying, here's a circumstance, but even with the evidence that I'm hearing where there's coaching of the child that's apparent on the stand in front of me, I'm rejecting that argument. And so it's a problem. And it's something that courts are tasked with. And here we have one side of the order where a court does find he has parenting time and he's not getting it. And I'm finding that he's met his burden for that.
I'm still not understanding how, even if he's not getting his parenting time, how that there's another step. There has to be some behavior on behalf of the other party to be an impediment to that judgment that becomes the contempt. What is that behavior here?
So I think, Your Honor, if we frame this in somewhat of a different context, it becomes difficult when there are kids involved. But let's think about, for example, how I frame this in my mind is refinancing of a marital home after a divorce, for example. We deal with that frequently. We may say, you were supposed to refinance the marital home, you didn't it. And the other party brings a contempt proceeding and says he didn't refinance the marital home. There, by the virtue of that party not refinancing the marital home, there's not a specific action that was taken. It's nothing that you can point to and say, he went to the bank and then failed to fill out the rest of the applications, so he should be in contempt. It's the failure to act in that circumstance. Once the party has shown that the home hasn't been refinanced, then the burden flips to the other party to say, I can't afford to refinance, or I have an ability to comply because I'm trying and the bank is moving slowly. So it's not always having to point to one specific act. My client's not there for parenting time. He can't testify as to what happens behind closed doors. There can be a failure to act as well that says, based off of the circumstances and based off of what's going here, based off of the testimony I've heard, it's this failure to act that is justifying a finding of intent and willful and excusable behavior.
Yeah, but a failure is like refinancing. You can say they did not go to the bank, they did not fill out the application. There's direct omissions. What is the direct omission here?
Your Honor, I'm not sure there has been a direct omission, and I don't want to point the court to a direct omission, but we do have a timeline establishing what exactly has happened here, that there was a report of to law enforcement of what the kids had experienced in the plaintiff's home. Then there was a DVPO proceeding brought. The DVPO proceeding was dismissed. And then parenting time still doesn't happen, or it's supervised, which in and of itself is a violation of the judgment. When plaintiff starts putting terms in that aren't in the judgment saying your time is going to be supervised. That was never asked for until after this application for order to show cause. Then we have another DVPO proceeding, and then parenting time still doesn't happen. And we're looking at intentional disobedience, resistance, or obstruction of the authority, process, or order of the court. So we do have that disobedience, process, or order of the court. And what the district court says is, looking at the circumstances here, you acted egregiously. You continued to block the kids. You continued to not allow him parenting time. You were moving you were moving the bar on what was required for him to get parenting time without a court order. And as an attorney, you know better than to do that. And that can be taken from the circumstances. I don't think, in my experience practicing and dealing with contempt proceedings, a party is ever going to go on the stand and testify, I intended to violate the judgment. There's going to be these defenses and reasons, and it's ultimately the court's decision to hear that testimony and decide, do I believe it or not? The judgment was that Eric would get every other weekend of parenting time in 6 weeks during the summer. He demonstrated that he had not gotten that time since January 2024. Sarah didn't dispute that fact. Rather, there were reasons or excuses which the court rejected. For example, as I already briefly touched on, she states that she assisted in parenting time by bringing the kids to Kids First for parenting time, without acknowledging that that requirement of Eric receiving supervised parenting time is in of itself a violation of the judgment, as there was no requirement for that until December 2024, after the application for order to show cause was written. The plaintiff was writing terms into the judgment. As a lawyer, she knows better. She knows there are mechanisms to modify a judgment. That was not done until after the order to show cause was issued. The district court here made very specific findings justifying its order for contempt. It addressed the 2 periods of time in which the temporary DVPOs were in place and concluded that even after both proceedings, Sarah continued to restrict Eric's parenting time and communication with the kids. The district court specifically rejected Sarah's position on appeal that the children were refusing parenting time with Eric, and instead concluded that Sarah essentially retaliated against Eric for Eric calling in a welfare check for the kids when TNT reported an incident at Sarah's home. The court did not put weight onto that argument. When we're dealing with the abuse of discretion standard, this should be affirmed. Sarah next makes a similar argument that the district court abused its discretion because its decision is not the product of a rational mental process leading to a reasoned determination and was unreasonable. This argument largely focused on the testimony of TNT, one of the party's children. And despite the claim in the reply brief that Sarah is not asking this court to reweigh evidence, that is exactly what's happening here. For example, Sarah claims that there is no evidence to support the finding that she coached a child. The district court observed the testimony at the hearing. It made findings that go beyond what this court will read when it reads the transcript. The district court described the tension that arose when Sarah began questioning TNT, and specifically why the court believed it was coach testimony. Those were reasonable factual findings, and they are not clearly erroneous findings. It is clear there is a continued total lack of recognition by Sarah regarding her own actions, or the lack thereof regarding the order issued by the court in April 2025. For example, in paragraph 4 of her reply brief, Sarah states Eric falsely claims plaintiff continued to restrict his parenting time following dismissal of the DVPOs. Number one, it is true that Sarah continued to restrict Eric's parenting time following dismissal of the DVPOs. Supervised parenting time was not required until December 2024. Number two, Eric's brief do not at any point imply that he was entitled to parenting time while the DVPOs were in place. Sarah's position is essentially she wants the court to take Eric's testimony, but only 2 specific portions that are favorable to Sarah, rather than all his testimony as a whole, as true, while wholly ignoring that Eric also testified to Sarah blocking contact and communication between January 2024 to January 2025, which the court ultimately agreed with in its finding of fact. The district court's order here was very specific. It was a 13-page order going through the testimony that was heard. It made an analysis of the contempt statute, and it looked at what sanctions were appropriate. The district court concluded specifically that Sarah was a non-credible witness and discounted her testimony. And those are the findings that this court reviews in its abuse of discretion standard of review. Taking everything as a whole, the district court rationally concluded that Sarah had inexcusably violated the judgment. and this argument should again be squarely rejected by the court. Sarah finally argues that the court's order for compensatory make-up parenting time and attorney's fees should be reversed. Sarah's argument is largely that the order finding her in contempt was an abuse of discretion, so the sanctions must also therefore be an abuse of discretion.
Counsel, before you get to the merits of the attorney's fees and compensatory, are those orders on appeal? Have they been appealed from?
Your
Because
Honor,
I'm looking at and maybe I'm missing a supplemental notice of appeal, but the notice of appeal is from June 2nd, 2025. The two of the orders are from August. One of them is from May, but the notice of appeal specifically identifies the April 4th, 25 order.
correct, Your Honor. And I did point that out as to the compensatory make-up time with that provision relating to 7 days consecutive parenting time. The only order that was appealed was the April 4th, 2025 order finding Sarah in contempt. There is references that the court is going to order compensatory make-up parenting time and attorney's fees within this order on April 4th. But then as to the specific orders for these are the days that you're getting for compensatory make-up parenting time, and these are the amount of attorney's fees you're getting, those were subsequently not appealed. And so when we get into the merits of those two orders, as far as beyond the fact that I am ordering those are not on appeal. But I think the fact that they were addressed within the order, this court can generally look at remedial sanctions in general.
Thank you.
Yeah. It is correct that remedial sanctions are not appropriate when the district court does not find a party in contempt. In this case, as has already been adequately briefed and argued, the court did not abuse its discretion in holding Sarah in contempt. Sarah's position relied on the case of Sims versus Sims. That is a case where the district court found the mother was not in contempt, where she put the children on a plane and the children snuck off on their own contempt. Likewise, here, in that case, the district court considered the evidence and exercised its discretion and concluded there was no contempt. Likewise, here, the district court exercised its discretion, with the difference being that it did find contempt. At first glance, the standard may seem to be that we have conflicting decisions, but that is not the case. The theme in both cases is that the district court gets to decide whether someone is going to be in contempt after considering the evidence before it. So then the question became, what are appropriate sanctions? A remedial sanction can include monetary sanctions to compensate a party for loss or injury suffered as a result of the contempt. The district court ordered 30 days of compensatory make-up parenting time, an appropriate sanction when Eric had missed over a year of parenting time. That is a remedial sanction, as it compensated Eric for the loss of his parenting time as a result of Sarah's contempt. The district court also ordered Eric's attorney's fees for having to bring his application for order to show cause. Prior case law is clear that attorney's fees for having to bring such an application are appropriate as a remedial sanction. The provision specifically related to 7 consecutive overnights is not on appeal, as Sarah did not appeal that order. Again, these issues are to be determined under the abuse of discretion standard of review, and there was no abuse of discretion. In sum, all of Sarah's arguments are not supported by the law and lack any merit, especially against the backdrop of Sarah being a licensed attorney, and the court should affirm the April 4th, 2025 order holding Sarah in contempt. So with that said, Eric requested attorney's fees in conjunction with this appeal. The governing standard of that is Rule 38 of the North Dakota Rules of Appellate Procedure, which provides that if this court determines an appeal is frivolous or that any party has been dilatory in prosecuting the appeal, it may award just damages and single or double costs. My client's position is that this appeal is both frivolous and dilatory. As to frivolity, the standard is to whether there is such a complete absence of facts and law that a reasonable person might not have thought this court would render a favorable judgment on appeal. While Sarah had an ability to appeal the order, Sarah's argument sidestepped the appropriate standard of review and asked the court to reweigh the evidence. Eric spent about 5 pages of his brief correcting misstatements of fact, including continued assertions that Eric was found to have groomed the children, there was an attempt to misrepresent facts, including citing to portions of the records that didn't support the statements, or citing to exhibits that were filed after the end of the hearing. We do also believe that this was dilatory in nature. So for the foregoing reasons, we do request attorney's fees and ask the court to affirm. Thank you.
Ms. Hackman, thank you for your argument this afternoon. Ms. Kite, whenever you're ready, you can release your mute and begin your rebuttal argument.
Thank you. So Ms. Hackman stated that Mr. Thornburg had sporadic parenting time, and I just want to point that out because there was 2 domestic violence protection orders. There were some children going, some children not. There were times where he voluntarily agreed to have supervised visits at Kids First in Grand Forks. Then there was a police investigation ongoing where the children were talked to at Red River Children's Advocacy Center. They were told not to talk to him during that investigation for at least some portion of the time. And so they asserted their Marcy's Law rights. There were emails between attorneys about this. And then Mr. Thornburg comes up with a random number of what he would like for compensatory parenting time, and the district court granted 30 days, but doesn't clarify when he was entitled to parenting time, what parenting time he got, and what was interfered with. But even if there was to be a remedial sanction of compensatory parenting time, the district court's order is unclear and unhelpful as to what parenting time he was entitled to that was interfered with, that he's being compensated for.
Ms. Kite, can you address how or why we would address the merits of the compensatory parenting time and attorney's fees? They seem to fall outside of the notice of appeal.
So the original order from the district court granted attorney's fees and compensatory parenting time.
But no amounts?
Right. So in general, I'm just asking to reverse all of them. It's okay, not an argument.
That's my question is, so they're in the original order, the facts, would we look at them? We seemingly wouldn't look at the details because the detailed orders were not appealed from. Would we just look at whether those remedies are available as remedies in a contempt proceeding?
Correct. And in addition to that, once it's appealed, the district court was without jurisdiction to make any further orders that could affect the order appealed from. And so that's all we really can appeal at that point in time is the initial contempt order that says compensatory time and attorney's fees are being ordered.
The compensatory time order was out before the notice of appeal, so that could have been appealed, and the district court had jurisdiction for that, correct?
I do not recall, so I don't want to.
2025?
It could have been. I don't want to say incorrectly. Ms. Hackman argued that the child's preference can be raised as a defense, but I think she's completely sidestepping the point in that the children's actions cannot be imputed upon a parent. You can't say this parent has willfully and inexcusably violated a judgment based on another person's actions, the children's actions, the children who are the ones who are, of course, going to have feelings, thoughts, opinions, and actions. And Ms. Hackman argued that, the district court found, there was enough evidence, but really the children's actions speak volumes. Actions are a language. Actions show a lot. And that's not something that can be said to be imputed on somebody else. Ms. Hackman talked about a police report from Mr. Thornburg, and I kind of want to touch base on that timeline. There was, in the beginning of the school year of 2023, multiple police calls while I was at work from Mr. Thornburg about the children not going. Then there was a situation where my daughter was unhappy with a reprimand she received in my home. She had called her father, and then a few hours later, he contacted police. He sent a text message saying, I'm sorry, they spoke that way to you. They'll learn if they haven't already that they can't speak that way to you. I quoted the exact text in my brief, but something along those lines. Then later, after I get a protection order, he testified in front of Judge Whalen that he did not know he was going to go to the police department. He goes to the police department, all of a sudden making claims of abuse, telling the children to lie, or otherwise they won't see him again because mom he called it a restraining order, but it was the protection order. So then they go to law enforcement. It's my understanding that the children didn't even say the things that he wanted to, that case was closed out. Nothing ever happened. And then he took the children from the police department in violation of that protection order. He knew about the protection order before going to police. So the timeline on that is kind of important because Ms. Hackman's saying that I coached the children on what to say to police, but Mr. Thornburg's own testimony is that he didn't even know he was going to police. I didn't know he was going to the police. No one could have known that he was going to react that way upon learning of a domestic violence protection order. In addition to that, he's making claims of abuse all of a sudden, and his text message shows that the only concern was what was said to my daughter as a reprimand, not...
Ms. Kite, I have a question. This domestic violence protection order you're discussing, this is one of the 2 temporary orders, or was there ever a permanent order in place during this time period in dispute?
It was the first temporary one.
Okay.
In January of 2024. So he changes his story. So now they want to claim that I coached the children on what to say. My daughter testified at the second protection order hearing. She testified at the contempt hearing. She had forensic interview with Red River Children's Advocacy Center. She has spoken to multiple police agencies. So her story has never changed, but his story does. In addition to that, I never knew she was going to the police. There's no way I could have coached her. But in all of the times that she's testified or given an interview with police or other investigators, she has said, my mom just told me to tell the truth. So I think it's rather concerning to say that that's coaching and insinuate and misimply that that was somehow a negative thing. Coaching can be a great thing, especially if you're telling people to tell the truth. Whatever you want to call it, she's testified repeatedly that her mother told her to tell the truth. Her mother told her to tell the truth. In fact, all of the children have said that. So I think it's important to get that clear. There was no way that anyone could have coached a child, but that child in particular has repeatedly said she has been told to tell the truth. And in addition to that, when the district court makes findings about me on cross-examination questioning my own daughter, I stopped because she was crying and I did not make her answer as to specifics of what her dad has done to her. Those specifics have been outlined in my own petitions, my own testimony, and to force this child to have to testify again and again and again, or have interviews again about what her dad has done to her, the sleeping in the same bed, the hand holding, the rubbing her inner thigh. Of course she has emotions about that. And oftentimes children do, express those emotions, cry when they're looking at a safe person, a safe parent. And so the district court can think what it wants, but that's my point, is that it doesn't stem from evidence. It doesn't stem from...
Well, it does. It's for the trial court to assess the credibility of all the witnesses, including you and your children. And my recollection is the district court had a specific finding regarding your credibility. So we're not going to reweigh and reassess what the credibility findings were. That's not our role, is it?
No, absolutely. And that's where I was going. The district court can make whatever findings it wants on credibility, but that is a far leap and cry and jump to what's evidence for blocking parenting time, what's contempt. You can believe emotions, you can believe things like that from a child. You can think whatever you want about somebody's credibility, but the fact is that The evidence in the record, including social services testimony, including Mr. Thornburg's testimony, is all that I have never picked up the children from his home when they call me and say they want to come home. And he admits to that. I have never been home, attempted to stop them from going with him, and he admits to that. I've never done anything to stop him from picking them up from school, and he admits to that. He also admits that it's the children who don't want to go. So I think it's a fundamental difference between doing an action to stop somebody's parenting time to, blaming somebody. It gets back to the question, what am I supposed to do? It needs to be clear in the judgment. If I'm required to make them come back to his home when they leave during his own parenting time, it needs to be in the judgment. If I'm required to take off work every single time, no matter what time he wants to pick them up, then it needs to be in the judgment. Thank you.
Ms. Kite, your argument time has expired. Thank you for your argument as well.